So I recently had a client approach me after I did an estate plan and say to me, well, now that I've done my will, we can avoid the probate court when I pass away. And I said, no. A will is actually the instrument that gets introduced to the probate court when you pass away. So the question is, what simple things can we do to try to avoid probate for your family in the future? There are a few things. First of all, you want to make sure that you do have an estate plan in place no matter what the size of your estate or how many assets you have in your name. As I phrased it in past videos, which I've included in the description of this video below. If you're watching on Facebook, it'll be above. But as I've said in past videos, a simple estate plan is one that has a will, a healthcare proxy, and a power of attorney. Now, 2 of the 3 documents that I mentioned inside your simple estate plan actually do avoid the probate court for the most part. This is in general now, folks. If you should get sick or something should happen to you, or even if it's not convenient for you to handle your estate while you're alive, it's only while you're alive. The first is the power of attorney. Now, we usually do a durable power of attorney. So what is a power of attorney? Well, it's a simple agency that you're going to create in writing, whereby you're going to appoint an agent called an attorney in fact, as opposed to an attorney at law. And that agent is going to be able to handle basically your assets. That would be your real estate, your money, your investments. And also there are some general powers in my powers of attorney anyway, where your agent would have the ability to represent you in front of a court of law or in front of an agency like Medicaid or in Massachusetts Mass Health. And those are important powers to have. Now, what else can you put in place? Well, the second document that I mentioned is a healthcare proxy. And once again, this is a written agency that you're going to create. And basically what happens is if you get sick, you're going to have someone step into your shoes, collect the information about your treatments, your prognosis, and then make the call with the doctors while you're sick. Now, as you notice here, folks, with each document that I just mentioned, I have not mentioned approaching the probate court for any reason to grant your agent the authority to act on your behalf. So for the most part, those 2 documents do not involve a judge or a probate court. In those documents, you designate the agent that you want to act on your behalf. So there's no court involvement. Now, what else can you do? Well, you can create a trust. Now, a trust is a written document whereby you create a fiduciary arrangement with a manager of the trust called a trustee, where you put assets into the control of that manager, of that trustee, and the trustee has to act in accordance with the terms of the trust that you draft. And then those assets are handled on the behalf of other individuals or an individual that we'll call beneficiaries. And so, once again, if something should occur, the trust would control your assets or the assets that are included inside the trust. And once again, no judge necessary, no court necessary. What else can you do? Well, we can take some simple actions. Let's say you have some bank accounts out there, or you have some investments out there. With bank accounts, you can just simply add another individual that you trust onto your accounts with you. You can hold it jointly as joint tenants with that individual, which would mean that there would be a right of survivorship. So if you should pass away or if something should happen to you, the other individual would have control over the account. Or you can do what the bank phrases as TOD, transfer on death, or POD, pay on death. You could designate an individual or individuals that way on your accounts. What other simple actions can we take to avoid the probate court? Well, if you own real estate, you can certainly create what we call a concurrent tenancy. And once again, I've talked about this in the past, and I'll include some videos inside the description. Make sure you check those out. They'll be shorter. But in general, when you create a concurrent tenancy, we're going to presume that you want to create a concurrent tenancy that has a right of survivorship in it. And so the basic 3 types of concurrent tenancies that you can create is a joint tenancy, where you don't have to be married to the person. It could be a relative or a friend that you hold title with, and if something should happen to you, they receive title, full title in the real estate by operation of law. The second type of a concurrent tenancy that has a right of survivorship would be a tenancy by the entirety. And with a tenancy by the entirety, you have to be married to the other individual. And once again, there's a right of survivorship. So if you should pass away, the surviving title holder would then receive 100% of the real estate. Then the third type of a concurrent tenancy when it comes to real estate would be a life estate. And with a life estate, where I typically see these come into play, mom has a piece of real estate and she wants to involve her children in her estate, so she may name them. This is just simple now, right? Because we actually do a lot of more sophisticated things with life estates. But she wants to make sure that her children are involved. She'll name them on title with her and reserve a life estate for herself. And basically what that means is she has the right to reside upon the property for her lifetime, do all the things that a title holder should do and has to do, like insure the property and pay the taxes and maintain the property. And then upon her death, by operational law, no judge necessary, no court necessary, title would then transfer to her children that she names on the deed with her. So that would be another type of a concurrent tenancy that, for the most part, will avoid the probate court. So those are some simple things that you can do. Of course, when I get involved, we actually take a look at an individual's estate and then determine what direction we should go, and it's not always that simple. But those are just some ideas of things that avoid the probate court and avoid a judge down the line. Now, if you're watching me on Facebook, make sure that you like the video. If you're watching me on YouTube, make sure that you subscribe in the lower right-hand corner. And some of my prior videos will be appearing here. Make sure you check some of them out. They'll be related to the topic that we're discussing here. Dave Ceruolo, CeruoloLaw.com.